Hello everyone, I'm Sharon Gaynor, Training Research and Development Assistant with Haven Horizons and Knowledge Broker on the Community of Practice. Today we are delighted to welcome Dr. Niamh Maguire from SETU to discuss her work. But before I hand you over to Niamh, you're all very welcome, of course, but just a special welcome to any new members and those who may be joining the Lunch and Learn for the first time. A brief run through of the format. If anyone has any questions during the presentation, feel free to add them to the chat and we'll post them to the Community Lunch and Learn section afterwards. I'll give a brief community update after the presentation. Now, Dr. Niamh Maguire is a senior lecturer in law at the Department of Law and Criminal Justice and is co-director of the Crime and Justice Research Group at the South East Technological University. She teaches a range of modules to undergraduate students at SETU, including gender and criminal justice, criminology and comparative criminal justice systems. She researches and publishes across several key themes, including criminal law, sentencing, probation and community sanctions, penal decision-making and comparative criminal justice processes. Her sentencing research has been cited in several Law Reform Commission reports over the last 2 decades, most recently in the LRC's report on mandatory sentences 2013 and its report on suspended sentences in 2020. Niamh was commissioned by the Judicial Council to conduct a study of District Court judges' views on sentencing and the sentencing of relationship violence. This is the first report of its kind in Ireland that has examined judicial views regarding domestic abuse and coercive control, and it focuses primarily on how district court judges approach the sentencing of Section 33 breaches of protection orders in Ireland. The key recommendations from this research were adopted in full by the Sentencing Information and Guidelines Committee of the Judicial Council, and the report was published in December 2024.
For inviting me back. I have listened to your feedback and I'm going to be quite specific. I'm not going to do a general introduction because that will eat away at our times. I think the previous presentation where we do that general piece is already available to view. So today I'm really just going to focus on, I'm going to look a little bit more at Section 39, coercive control and judicial perspectives on that. I'm going to look really briefly at Section 40, judicial perspectives on that. Interestingly, last week, the Judicial Council issued its first ever sentencing guideline on Section 40. I won't be talking about that, but at least if we look a little bit at Section 40, you'll have some background information with which to view that with. I won't be talking about that because I haven't had a chance yet to properly digest it. But it's good news anyway that they have done that. And then I suppose you asked for me to focus a little bit more on the recommendations in the report. So that's what I hope to get done today. So what I've actually done, instead of doing up a brand new presentation, I've just added a few bits in, and that can be uploaded then, and you can look at it in more detail later. So the main point of the last presentation and of one of the main focuses of the report in terms of how it relates to sentencing of relationship violence was really Section 33 of the 2018 Act. That's when there has been a breach of a protective order, such as a safety order or a protective order or any of the range of different protective orders. I had made the point that that was based on that section is the only true way that domestic violence is prosecuted, or has been for a long time. With the introduction of Section 39, we've seen a lot of prosecutions, usually kind of high profile ones, quite serious ones in the circuit court. And I suppose that's introduced a new element. But outside of those two sections, we don't really know a lot about what's going on in terms of the prosecution and sentencing of domestic violence. In other words, when a straightforward assault or a rape or a sexual assault or a stalking or any of those offences are prosecuted, we don't know how prevalent domestic violence is, or so we don't have any stats on that. What I'd like to focus on today then is, one of the points I made about Section 33 was that it's very it's very kind of very much based on the incidental model, which means that it doesn't really capture very many different complexions of domestic violence, particularly coercive control. And that, you know, introducing Section 39 then was, the hope was that that would be specifically covering that whole area of control, controlling and coercively controlling that form of domestic abuse that was kind of omitted from Section 33. So I'm going to just jump straight into Section 39 and Section 40, and that does require me to go here. Just 1 second, I need to get this closed down. Yeah, so Section 39, I'm not going to go through the definition, but essentially what did judges think about it in the district court? So firstly, at the time that I did the study, I suppose, collected data 2022 to 23, and there had only been, I think, there was only one judge that we interviewed that had heard a Section 39 prosecution, and almost all judges that we talked to basically felt that, or thought that there had been no prosecution so far in the district court, and many indeed expressed the view that they thought that Section 39 would be quite a serious kind of charge, and that maybe it would be too serious for the district court, and that they were feeling that they would probably decline it. Obviously, it depends on the circumstances of the case, but their view or understanding of it was that it would be too serious for the district court, and that most of these cases would be dealt with in the circuit court. And this was quite interesting because in terms of the prevalence, when we asked them a little bit about the prevalence, well, would you see much controlling behavior, you know, in Section 33 in those kind of cases? And like 1/3 of them said, oh yeah, absolutely. It's very common to see controlling behaviors and, you know, even coercive control in the context of a Section 33 breach. And, you know, so that was kind of interesting that they could see that that this kind of behavior was already part and parcel of, you know, it was already coming to the district court, but under the guise of Section 33, a breach of a protective order. So in any case, they felt, so they were seeing that controlling behavior, but not, there weren't specific prosecutions for it. And in terms of how they might handle that prosecution, a lot of them, at least 1/3 of them anyway, noted difficulties in terms of evidentiary proofs required. So they kind of did understand that this was a totally different way of prosecuting domestic violence, and even, you know, it wasn't based on the incident model. It's more this pattern of control and impact and all of the different things that had to be proven. None of them had, I suppose, training on this area, and so what I was hearing was, you know, a bit of concern around the actual realities of trying to prosecute and, you know, and process these types of cases in the district court without any of that training and backup and knowledge, because it was a brand new offence. And so I'm going to just show you now one or two excerpts, or like one excerpt actually from what a judge said that will kind of sum this up. One of the things they mentioned was the credibility of witnesses, that could be a major factor, but it wasn't just the credibility of witnesses. Just need to, yeah. So as you can see in this extract, sorry, it's a little bit small, but this was at 107 of the report. One judge identified various difficulties, and these included, in terms of prosecuting coercive control, it can be difficult for a judge to understand in the first place. So they have to be really, you know, really up to date and understand what they're seeing. It can be difficult for the complainant, the person coming in. Sometimes some judges mentioned that some complainants really didn't seem to realize themselves the extent of control that they had been placed under. And also then the difficulties of giving evidence in court, and also being cross-examined by the alleged perpetrator. So the fact that the person might just be too overwhelmed, or that they're so worn down by the abuse that actually, you know, and then they may be prosecuted. So all of these difficulties, just read it out there. Section 39 is very, very difficult. Coercive control, it's even hard to make a decision. Well, I suppose depending on what they say, coercive control is really difficult for a judge to define. Like, I really don't understand why. I mean, I do understand why women don't stand up for themselves, but as to my nature and my perception of, well, if you give me a puck, I'd puck you back, you know? It's difficult to understand why women allow this to happen to themselves. But then again, You have to understand it, and you have to understand the literature, because it often sounds exaggerated by the woman, and yet you have to see it as being a crime. And I suppose you have to, this will all go down to body language or to credibility. Who do you believe? It's all very, very difficult for women to express it sufficiently well when they're in the box, because some of them just disintegrate. They're not able to say what's wrong with them. And of course, a lot of them are subject to cross-examination by the other half. And a lot of these will be without legal representation. So in a way, it's a really good, that quotation is a very good summary of all of the complexity involved in this area, you know, even from the judge, even from like, you know, the psycho-educational point of view, like, does the judge understand it, but also the whole evidentiary, the whole legal side of successfully prosecuting this, and then the whole side of you know, getting the evidence, and you know, the credibility and the body language and the impact, and it's so incredibly complex. So I just thought that was worth delving into a little bit, and then just some views on judicial perceptions of Section 40. I'm not sure if you're familiar with it, but a Section 40 is little known but potentially highly influential section of the 2018 Act. And it provides that intimate relationships. So when there's an intimate relationship between the defendant and the victim, that this can be seen as an aggravating factor for relevant offences when a judge is sentencing. So, for example, if it's an assault or an aggravated assault or whatever, and it's not, of course, a controlled case, and it's like under Section 39, it's not a Section 33. If it's prosecuted as an assault case, but there is it's a sole case between intimate relationship, victim and defendant are our partners, then that very fact in itself can be taken as an aggravating factor, and they can be sentenced more severely, I suppose, more punitively than if it was a stranger assault. So there's a whole list of offences in Section 44, and some of them include violence, sexual assault, rape, and there's a huge amount I'm not going to go into the list, you can look that up. So in terms of judicial perspectives in the district court, most had heard about this. They kind of knew about it, but they had never used it, and they weren't they could do with more information and training. And yeah, sorry. And that in relation to the recommendations I made in the report about Section 40. So there's two there, sentencing guidance on the application of Section 40. In practice, focusing on how much weight should be given to the existence of the relationship between the perpetrator and the victim as an aggravating factor when passing sentence in domestic violence cases. And basically just information on the types of cases that it might arise in. So as I was saying to you, they recently, last Friday only, published their very first, the Judicial Council, the Sentencing Guidance and Information Committee, published their first sentencing guideline, and it's on Section 40. So it's really, really worth looking at. It's very, very interesting, and I haven't had a chance to digest it yet, which is why I'm not going to talk about it here today, but definitely one for another day, because I think what they've done is they've piled a lot of what they believe judges should be looking out for in domestic violence cases in terms of sentencing into this recommendation. So that needs to be carefully examined. I don't know how much time I have. I was going to go on to recommendations.
You've got 15 minutes.
15 minutes. Oh, great. Okay. Sorry, I thought I had less time. Yeah, so the other thing that you asked me to look at was to focus more on was the recommendations. And I suppose the recommendations can be broken down into two kind of categories. The ones specifically for the Sentencing Guidelines and Information Committee, which are on page 152 to 156. And then the ones that were more general for other kind of bodies or organizations, like the policy related ones, the research related ones, the legislative related ones. And they're I'll deal with them if we get time, which I hope we will. So I suppose the recommendations were broken down into, I suppose, three types in terms of, there was the provision of sentencing information, guidance, and training to complement the guidance. So I suppose the point I was trying to make in the report is that if you just give information on its own, well, that's better than not giving information. But don't know if anybody's read it, and it can be very difficult for judges who are extremely busy, massive caseloads, and and lots of things coming at them. And you've got to remember as well, I suppose, that sentencing judges aren't just sentencing judges. They also are, quite often have a civil jurisdiction as well. So, road traffic courts, they would have a licensing that have in. So just giving out information on its own isn't enough, but it's a good start. And but this needs to be linked with guidance, and then the guidance, you need to give them training so they understand how that applies. So I try to, wherever possible, provide recommendations in a particular area that kind of linked those three things. But even if you look at the Sentencing Guidelines and Information Committee, that's just one committee in the Judicial Council, and there's a different committee for judicial training, which then means that in a way, the training aspect of it is kind of outside of the remit of the Sentencing Guidelines and Information Committee. So in any case, I'll move on. So just try to compress down the number of recommendations and kind of try and focus on the most relevant ones. And so I suppose the first one I'm going to look at here is the specific ones about domestic violence. So the provision of research and trauma-informed sentencing information on. So the different forms, this is quite basic, but the different forms of domestic violence and their impacts on survivors and victims and children, to enable judges to correctly assess the nature of the harm involved. Well, really, first of all, even to recognize what they're seeing before them. And then the response is then to be able to assess the nature of the harm that they're seeing before them, and thus then decide on the seriousness of the offence. So judge's job is really, the principle of proportionality in sentencing, which says that when they're deciding sentence, they need to make it proportionate to the circumstances of the crime and also the circumstances of the person who committed the crime. Okay, so the circumstances of the crime is the first thing. That's what we talk about, the headline offences. And within that, you need to look at the harm caused and the culpability. So in setting the headline offence, you have to look at the harm caused and the culpability. And if judges can't recognise and respond correctly, or in authentically and in a way based on their understanding of what's going on in terms of domestic violence and coercive control, then they can't do that step of assessing the harm and assessing the culpability, and therefore, correctly assessing the seriousness of the offence. So that whole, judges need to be equipped or enabled to identify the different forms and their impacts. That's the very first thing. The next thing there was the various ways in which victims and survivors of domestic violence can experience re-victimization. So I think, in fairness, there's a number of reports that have highlighted this, and so that wouldn't be brand new to judges, but it is really, really important to understand how they experience this, but even also the trauma-informed understanding that maybe in the previous quotation you saw a judge say, well, sometimes the victim or the complainant will disintegrate in the witness box. They can't give their evidence. I mean, that's a trauma response. So the fact that really, that's why really judges need to be informed about the impact of trauma in this context, and that so they can recognize it if they see somebody disintegrate, and they can take an adjournment and allow them time and make sure they have the proper resources to assist them. Sentencing, another important recommendation there was sentencing domestic abuse bench book for district court judges. And I believe this one, at the time I made the recommendation, there was somebody already working on that. And I believe there is one, although they haven't officially published it. I think there is one, at least for district court judges. The various proofs necessary to ground a conviction under Section 39. So that relates to what we were saying about, I mean, from my perspective, I interpreted it as a little bit of anxiety that district court judges were feeling about, okay, here's this new offence coming, it looks really serious. And actually, if you look at it in detail, there is a lot involved that you have to prove. And one of the things they constantly highlighted was the difficulty around the evidentiary proofs for section section 33, that this was one of the reasons, not the only reason, but one of the reasons why so many of these prosecutions are withdrawn, because in many cases, for example, they have to prove that the perpetrator knew, or that they knew that the order was published to them and they have to prove that the perpetrator knew the order existed and it was furnished to them. And if that proof isn't there, the whole case falls. And so that's a bit of a complicated conversation, but the point is that they need some guidance, and they need some training around, this whole area of Section 39 and what it means. And this is particularly important because we know in England and Wales that introduced this section quite some time ago, that they are having difficulties. And there's a lot of literature on that now and some research on it about the difficulty, proving this section. Of course, we took our Section 39 right from the similar section. So we based our Section 39 on the one in England and Wales. That's now been proven to have a lot of difficulties in terms of the proofs. So that's Section 39. Section 40, so just basically to give them some more information around what Section 40 is and the types of cases that it could arise in. So case examples, for example. So so that was the information bit, and then the next set of recommendations really were about the sentencing guidance bit. So so the provision of research and trauma-informed sentencing guidance. So research-informed and trauma-informed. So to make sure that when they give some sentencing guidance, that actually each part of it, they have, taken the time to make sure they've looked at it in terms of, that they understand the research behind the area and the field, so it's best informed. So looking at the first bit, then assess the harm. So that seemed to be really crucial part, that if you can't recognize domestic violence, or the various forms, then if you can't recognize it, then you can't respond to it, you can't assess it, and you can't then feed that into your response. So assessing the harm caused by the breach of the protective order and or involved in cases involving domestic violence should focus on helping judges to recognize and assess the impact of the various harms, in particular psychological, emotional, financial, and physical. And this goes directly to the question of the seriousness of the offence. So making that connection all the time. And I think that was kind of important for me anyway, was to try and make the connection to the sentencing bit. So you need to understand the domestic, what you're seeing, in order to be able to assess it and then to be able to make the decision about seriousness. So ultimately for judges, they want to know, why is this relevant to me in sentencing? Well, the relevance is because you have to decide how serious this case is so that you can pass sentence in it. And how do you do that? Well, you have to assess the harm and the culpability. Well, how do you assess the harm? Well, you have to be able to recognize the harm. So in a way, it was kind of working backwards a little bit. The weight that judges should give to victims' requests regarding the sanctioning of a person. And in fact, I did have a quick look at the new guideline, and it does refer to this. And in a way, I would love to have your views on some of these things. So I think if there's interest, we could definitely do, I don't know, maybe a round table or something on the guideline. But there is, they have made recommendations around the victim's requests regarding sanctioning, and they basically said that sentencing is a judge's job, and whilst, and they've said, whilst it's important that we get victim impact statements, that it's only really relevant to certain elements of the decision, and that the sentencing, the sanctioning is what the judge decides. Anyway, so moving on to the next bit, taking into account the impact of domestic abuse in all its forms on children. And I think this is very, very important. And that was, in fairness, they deal with it in their guideline again, which is also very interesting. And they really do focus on not just seeing children as a witness and understanding that they are a victim as well. So if they're experiencing it, even if they're upstairs hearing the noise or whatever, they are a victim as well. And I think that's really good part of the guideline. But I suppose I had a number of recommendations specifically focusing on that we need to understand the impact on all parties, particularly children, and looking at it from the perspective of the best interests of the child and the child being a victim in their own right, and then also the child welfare concerns. As we noted in the first presentation, this was an area, like many judges recognized that there were concerns, but weren't sure about how they were supposed to handle those within the context of a criminal prosecution for domestic abuse. And, you know, within a Section 33 prosecution, like what's their role as a judge? They weren't very clear on that. And so guidance about that. So yeah, another focus then was really a recommendation to help judges understand how they should approach the assessment of harm associated with psychological and emotional abuse, particularly when it's used as a method of control to gain dominance over a victim, and the circumstances in which an attempt to control the victim may be considered as an aggravating factor. When Section 33 cases and all criminal cases involving within, that should be within. Yeah, so this was quite interesting because again, one of the things I found was that there was a tendency among some judges to not really see psychological and emotional abuse as serious as physical. And then maybe this was related to maybe not connecting it with the different forms of domestic abuse, which is, for example, coercive control. That, you know, there are documented cases of domestic abuse and domestic violence that there has been no actual violence in, and that you know, if you're using control to gain dominance, that can be actually almost have almost worse impacts long term than the physical side of the abuse. So how to approach assessing that the harm involved with that. And then the last two things really were, in terms of the guidance, was the range of mitigating factors that can appropriately be considered within the context of domestic abuse. And I suppose just making sure that, you know, that when you're giving advice in the sentencing guideline, that you're doing the work behind it in terms to draw upon the literature to make sure that there aren't any unintended consequences. And again, the one that I had highlighted was, you know, it was widespread that judges were using living arrangements. So if perpetrator agreed to move out of the family home, then that was taken as a mitigating factor, and even to the point where it seemed like there was almost like a push that maybe that this was something that judges would look for routinely.
Sorry to interrupt, Niamh. We're coming to the end now, so just just to be aware of the timing.
Perfect.
Yeah, perfect. Thank you.
And then the other one was the aggravating factors, and again they have indicated in the new guideline they have looked at both of the aggravating and the mitigating factors. So and then, of course, the provision of research and trauma-informed training. So the next bit was the training, and again, it follows a kind of theme to be able to identify and assess and respond to and understand, etc., etc. And, you know, for example, training should specifically focus on familiarizing judges with the research and literature on the impact of domestic violence, particularly for coercive control and victims and survivors and their children. So there's lots there. There was other recommendations for other arms of the state, which I've highlighted there. I don't really have time to go into, but I've given you a bit of detail there. You can look at it if you want to. Specific ones for the DPP, specific ones for the Department of Justice and for CUN, and also recommendations for professional legal bodies, what they need to do next. And yeah, and so that's it. I hope that's been useful, and I look forward to hearing any feedback or any questions you might have for further clarification.